You may proceed.
Thank you. May I please the court? My name is Miles Jacobson. I'm representing Thomas Woods, the appellant. I'd like to discuss the first two issues that are in the brief. One of them, the first one, is the insufficiency of the evidence, and the second one has to do with the fact that the witness, some of the evidence in this case, important evidence in this case, was the grand jury testimony of the defendant. The defendant was subpoenaed, or I should say summoned, to come to the grand jury. And the summons, as summonses say, you're required to come and give evidence, furnish evidence, or testify in front of the grand jury. And in this case, the defendant was not given any kind of further notification that that command to testify, because the summons says, the Commonwealth commands you. In the name of the Commonwealth, you are commanded.
Is it your contention that at the time that your client was summoned to testify before the grand jury, that he was indeed a suspect or target?
I do think, Your Honor, that it's clear that he was a suspect of some sort. And the government says he wasn't just an ordinary person. We thought he was lying. That is in the hearing that took place.
I meant, but a suspect of some sort that he committed the murder? That he was involved in the
government doesn't say what he was lying about. But when you think of the facts of this case, this is a person where the victim was killed in the car that the defendant was driving.
Right.
The defendant then shows up at the police station 20 minutes later or so, bloody with the clothes. And the government, in the first interview with the police, take those clothes, photograph him, investigate whether he might be, whether there's evidence here of his involvement in this matter. So I think that when you look at the facts of this case, it's clear that the government thought this was a potential suspect. But Justice Botsford, whether or not the government really had him in its sights and intentionally called a target, and the government, let me start over again if I may. In its brief, the government says, well, the judge found in the motion that he was not a target. Now, there's a difference between a target and a potential suspect or a person of interest. And if you look at the instructions that are given in a federal situation, they don't just include targets. They include other people who might be of interest. But my point is even larger than that, Justice Botsford, which is Article 12 of our Constitution says that a person cannot be compelled to furnish evidence against himself. And we know from all the cases that there are that go back 2 centuries that furnishing evidence doesn't just mean confessing to guilt. It means giving pieces of evidence that in a chain end up being used potentially against you, which is clearly what happened here. What could be clearer than requiring a person to furnish evidence against himself, than officially serving the person, the government, officially serving a person with a document that says, in the name of the Commonwealth, you are commanded to appear and furnish evidence.
So I take it, that argument is, even if, take away this case, but just, act of God happens, the light shines, nobody thought that X person was involved or implicated. And then it turns out that, so it's an unsolved case, grand jury sort of. 2 years later, something happens that makes that witness before the grand jury all of a sudden the suspect. Regardless of circumstances, his or her grand jury testimony cannot be used because he or she was compelled to go, even though it wasn't in the context of anybody thinking that the person was anything but a sort of casual observer who had no contact with the crime.
Yes, Your Honor. It's not the only argument I'm making
No,
in
no,
this
but I
particular
mean, I'm
case.
just trying to take this.
No, I appreciate that. And I'm not waiving the facts of this case, however. In the facts of this case, as I'm saying, you have a person who in the motion session, the police officer who testifies says, well, we're not saying this person was a target, but he was more than just an ordinary witness. So what does that mean? What does that even mean? I mean, it's clear that this is a guy who they thought was involved by the time that they did this.
So what standard are you proposing? Are you saying that if anyone is a subject as defined under the federal
Yes, Judge.
U.S. Attorney's Manual? But a lot of folks are subjects. I mean, subject is a very, very broad term as used in the U.S. Attorney's Manual.
And it's a good term to use, as it is used in the Jewish because of the problem. This is not an ordinary situation where a person is either questioned by the police or even arrested and then questioned by the police. In those situations, what you're looking at is officers coming to that individual and saying, we would like to talk to you. Or they're just asking him questions. What about this? Were you here? Would you talk to us about this? So we're interested in voluntariness at that point. But we don't, in those situations, have a police officer who has said, in the name of the Commonwealth, you're required to answer this question. Think about that for a minute. That's huge, all by itself. What more does one need? And the remedy for that is simple. Tell people that the command to testify does not override the constitutional protection not to give evidence against yourself if it might tend to incriminate you. Easy.
And tell
And
them,
I'm sorry, Justice Kennedy.
and tell them that in front of the grand jury, or tell them that with an advice of rights attached to the subpoena?
Anything. In my view, anything at all would be potentially an answer to this concern. A document that was attached to the subpoena, advice, and in this case, when Mr. Woods came in response to the subpoena, and the judge finds that he comes in response to the subpoena to the grand jury, he's interviewed by the prosecutor and the chief police officer at that moment in time, who say to him, not, and by the way, you don't have to say things that might incriminate you, they say, your job now, go in there, give evidence, which is exactly what the summons says. Unqualified. How is a person supposed to think that that means, oh yeah, well, I still have my constitutional rights? And that's why in every federal case, this problem never arises. That's why in the Supreme Court's never had to address this matter before.
Well, the U.S. Attorney's Manual only speaks about advising a target. It doesn't require you to advise a subject, does it?
Yes, it does. It is not just limited to targets. If I could be wrong, Justice Grant, but I believe that that's in my brief, and it does. It's not just, there's additional warnings concerning targets. Whether you're a target or not is an additional matter.
And has any court gone that far?
I'm sorry, Judge, it's on page 38 of
No,
my brief.
you're right, I stand corrected. Has any court, federal or state, gone as far as you have said? I know that there are some federal cases which have suggested that a target warning is required. Is there any court which has said that as a matter of constitutional law, it's required for those who are subjects?
I cite a Second Circuit case, Your Honor, where the court doesn't reach it as a constitutional matter. What the court says is this: oh, you, the government, failed to do what your own manual says you're supposed to do, and therefore I'm going to reverse the conviction.
But we don't have a manual here.
Indeed, we don't have a manual here, and there's a problem. And the problem is that here, the prosecutors can do what they did in this case. Now, it might be that this problem rarely arises in the situation that Justice Botsford is referring to, where an entirely innocent, unrelated bystander happens to testify. It might never come up. The chances of it coming up might be weird. But this is not that case. So in terms of this case, the judge finds that the judge recites the proceedings here. He finds that Woods was not a target, but all the evidence at that hearing is that the government knew he wasn't just an ordinary witness. He was not the case, Justice Botsford, that you refer to.
No, I appreciate that.
Well, they certainly believed he knew more about the circumstances than he was telling.
Indeed. And what more could there be? What more there could be is, guess what?
Who did it?
Exactly.
Right. He knew more about that than he was telling.
Exactly. And he would have been within his rights not to answer that question. We probably all agree that that's true.
Well,
He would,
as it turns out.
Yeah.
excuse me,
Apparently, as it turns out,
Right.
that he would have been within his rights not to
Oh,
answer that question?
Well, in other words, if somebody, put the warning question aside, but if somebody's asked the question, is the police think he knows more than he has let on, why would it be inappropriate to ask, and for the person to feel some compulsion to answer, yes, I do know more, you know?
By compulsion, if what you mean is moral compulsion, I don't have a response to that. But if what you mean is legal compulsion, I think the answer is clear, he does not. Because he then is established, in the facts of this case, if he was just, again, an unrelated person, but who knew who the murderer was,
Right.
oh, sure. Yeah, if he's unrelated to all the facts of the case, but he happened to hear later on that the murderer confessed, oh, guess what I did at the Hess gas station? Yes, obviously, no problem. I mean, he would be required to testify. But in this case, he is furnishing links of evidence against himself. Oh, you met the victim earlier that evening? How do we know that, Your Honor? Only from one source, his, the defendant's. Oh, we talked about getting together later without saying?
Did he, when he talked to the police the night of the murder,
Yes.
I can't remember, did he go through that he actually had seen the victim earlier that night?
Yes.
I mean, so there is other evidence of that.
Oh, other than from the grand jury?
Yeah.
Yes, but the evidence in the grand, if we're going to get into an issue, that doesn't stop him from pleading the fifth, from taking the fifth. We, I'm sure, agree upon that, if he chose to, or if he understood that he could. And by the way, at the second interview of the police, there were two interviews of the police before the grand jury, he was told that he had the right to have it recorded. He said, I won't talk to you if you record this. So we know about him that he didn't want to give evidence that was recorded. But he, of course, had to when he was called before the grand jury. But Justice Botsford, when he is now, in terms of whether or not there is prejudice, that is, he already gave that information before, that's a different issue. And I addressed that in my brief,
right.
because it's clear they said you lied about this in the grand jury. If you look at the closing argument is you were at the grand jury, you lied about this, you lied about this, you lied about this in the grand jury. That is, they're using the grand jury as a major point in the case. So there's no doubt that there's prejudice. May I turn to the insufficiency aspects of the case?
sure, of course.
This is a case, the Commonwealth in its brief cites a case, Commonwealth versus Best, page 35 and I think 37 of its brief, for a good proposition, I think, which is a web of convincing proof can be made up of inferences that are probable, not necessary. So what's probable here? And I submit to you, very little that establishes guilt of the defendant. Well, one thing that we know is this. The defendant made threats. Oh, you owe me money, I'm going to kill you. And we also know from the government's witnesses, the victim did not think that was a serious thing. The victim did not think that meant something, that he was really going to be killed by this guy. So the victim who knew him and was friends with him was able to evaluate that. They met that night. They got together later at the Hess gas station.
Yeah, how did that come about?
I was just about to say, Justice Gordy. They met at the gas station, according to the government's evidence, because the victim, Mullen, calls the defendant on his cell phone. Not the other way around. And minutes later, just minutes later, because the victim lives nearby, the victim shows up at the Hess gas station, and very shortly after that, the killing takes place.
I thought there was a conversation about an hour before where they agreed to meet with each other later on.
Later on, vaguely and somewhere undefined. And the only evidence of that, Justice Cordy, is the defendant saying that. No one else is saying that.
So,
The defendant-
so the defendant says, called him?
No.
And asked him to meet with me?
No.
Okay.
The defendant met with the victim at a bar. They ran into each other at a bar. And they talked about getting together later. Later wasn't very clear, according to the defendant, who is the only person giving evidence here. It could have been the next day, it could have been later that night. They're going to
Together to what? To smoke a blunt?
Yes.
Okay.
It was, I thought it was pretty clear it was going to be that night.
No, I did too.
I think there's different statements that are given about that very matter. But later that night, fine. Let's get together later that night. Where was not decided. When was not decided. The reason why I'm focusing on where and when was not decided is if you think of what the government is claiming here, is that Woods set up this man to have him killed by two other people, masked men, who would appear at Hess gas station at a certain point in time, run behind the gas station, and shoot the guy. Think about what was, no evidence of Woods calling anybody else, no evidence that Woods knew these people, the shooter, no evidence of any prior contact.
So this Hess station, as I understand it, this is a hangout,
Yes, Judge.
and both the defendant and the victim had hung out there before.
Yes, and lots
Late
of,
at night.
And this place was packed at that time of night. Late at night, this is where you go.
So no big surprise, let's meet at the Hess station.
No big surprise. But on the other hand, could be lots of places you could go, or you could come to my apartment. They lived in the same area, but they're going to hang out at the Hess gas station together, smoke a blunt. And how does the defendant, in the government's theory, alert these two people to come and be on hand within minutes of that phone call that the victim makes to the defendant? And that it was in that direction is not only known because the defendant testified that that's what happened, but the government had cell phone records. And it shows that it's the victim who calls the defendant to get together. Fine. So somehow or other, now what happens? The victim sits in the car, is half lying down towards the center of the car. The defendant has gone into the Hess gas station. A masked man comes around the corner, and if you could see the chart, he would be coming around the corner, and the first thing he would be doing coming around the corner is running into this car where the door is open, and the man in the car is half lying down like this because he's dealing with something here connected to the blunt that he's going to be rolling. And he starts to get up when he gets shot. So why does this shooter shoot this man? And the government says, well, that's the plan, because we have no evidence that that's the plan, but there's a speculation. Could it be that that's the plan? It's hard to see how it got set up, but conceivably. But it also could be lots of things. It also could be that they came around, he was surprised by the fact there was a man lying half in the car, starting to get up. There's a man who had a gun, shot him. And one thing we know from the police officer who was at the scene, who responded first to the scene, is that there was another shooting down the road, very shortly after this shooting, that we know nothing about, but that comes into evidence. So possibly, if we're thinking about what's possible here, this shooter comes around the corner, sees this guy, is frightened or distressed by the guy who's coming, shoots him, and keeps on going, and then shoots whoever else he was planning on shooting before. Or possibly he recognized the car. He thought it was Woods' car.
Now address the defendant's apparent lying about his discussion with that unknown gentleman in front of his house after the shooting.
Okay, that needs to be addressed, Your Honor. When I think about that, one thing I was trying to think about was this. If we knew everything we know about the case, when we were police officers, but we knew them all at that moment when we saw that man in the driveway of his girlfriend's house. That's what we're talking about, the man in the driveway.
Right.
What if we had probable cause to arrest him for the shooting? Absolutely not. First of all, there are discrepancies in, so he's wearing black clothes or dark clothes. Great.
Arrest who?
The man,
the
other man.
Okay.
What have we been, because if you think about the government's case, he's the killer.
Right.
We don't know how he got there. Erin Andrews, I think her name is, the girlfriend, testifies, this is not, even though it's late at night and it's her driveway, the intersection that her driveway is next to is very busy. Lots of people are there all the time. Lots of people are wandering around all the time. So who this man is, and how he got there, and what that conversation was, who knows? We wouldn't, I submit, even have probable cause to have arrested him. Would have we had reasonable suspicion to ask him, who are you? Maybe, okay. That's a far cry from being able to make a probable cause determination, conclude that the inference is probable that that was the killer. I submit to you, that's not a fair inference. If you look at the descriptions of the people involved, there's a chart that I supplied where I tried to sort of isolate all the different evidence.
The Commonwealth's argument is not that it was known at that time, but that the fact that he is concealing the person's identity gives import to a meeting that otherwise may not have been that consequential.
And it would be if we thought we understood why that happened. First of all, how long that really took place, there's discrepancies about that. Whether he, his friend, he thinks, here's his point of view. My friend just got killed in my car. Could have been me. So the idea that he's not sort of focused on some guy in the driveway when he's trying to get into his girlfriend's house, I don't know what to say about that. Could you think, well, that's suspicious? I suppose you could think that's suspicious. But to conclude that that's the killer, what I was suggesting, Justice Gantz, is even if we know every single detail that we know now, that we really know now, not that we're supposing happened, there would not have been probable cause to arrest that man standing there.
Okay. Thank you, counsel.
Thank you.
Good morning. May it please the court. Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. I'll begin with the sufficiency of the evidence argument. The Lattimore standard is what controls here. So the idea of talking about probabilities of, is that possible that it could be someone else, or possible that it's a third-party culprit, something unrelated to the defendant, possible that he's a target. The defendant is drawing all the inferences in the defendant's favor, and that's not the Lattimore standard. And even under the federal standard, the due process standard, you see Cavazos, which is cited in my brief. The jury decides what conclusions to be drawn from the evidence admitted at trial, and you draw all reasonable inferences in the Commonwealth's favor. And that is the standard that we are looking at this case at. Yes, it is a circumstantial case, but it is a strong circumstantial case. The Commonwealth is required to show the defendant's guilt by joint liability. And in doing so, we have to show that he knowingly participated in the commission of the murder, alone or with others, with the intent required for that offense. And that's Zanetti, which post-dated the trial in this case, but really didn't change the law when you look at SOARS. SOARS is the same type of standard and the same type of instruction that was given in this case. So we look at first the intent, which is the intent to kill with deliberate premeditation. And that is very clear from the defendant's own statements in this case. From August to December, he was trying to collect this unpaid debt of $3,700. He started talking about the victim is lucky he's still alive, and that's because I'm such a good friend to him. Anyone else would be dead already. He says that in August. He calls, uses a racial epithet, says, you better have my money, and then says, or I'll shoot you. That's in October. And then 3 weeks before the murder, we see this escalation. First there's the indirect, he'd be dead already. Now there's the direct voicemail right to the victim. The victim's not taking it seriously, and the grand jury testimony shows the defendant knew he wasn't taking it seriously. He couched it in, we'd joke about our money issues. We'd laugh it off. He knew that the defendant was laughing these things off, and the defendant wasn't.
He knew the victim was laughing.
I'm sorry, the victim, yes, thank you. The victim, Paul Mullen, was laughing this off, and the defendant's still not getting paid. So 3 weeks before this murder, he's at that barbershop, and the victim's best friend, Flaherty, wants to buy a pound of marijuana for $1,300. And before their proposed transaction, the defendant starts in again. And he doesn't just say, I'm intending to kill him. He says, I'm going to kill him. I'm going to do it by shooting him. I'm going to shoot him in the stomach. And those are accurate predictive details. 3 weeks later, the victim is in fact dead. He has been killed. He has been shot. And one of the many places he was shot was in the stomach. And you can...
Are you, I mean, you're not suggesting, or are you, that it would be enough, just everything you said, and then Mullen is independently at the Hess gas station on the night of the murder, these masked men come, defendant isn't anywhere around. Would that be enough?
Just to state an intent, and then the guy ends up dead in the correct predictive fashion, I would say, no, that is not enough. But then, that intent and deliberate premeditation is shown over the course of that time period, along with that hour and 5 minutes of the planned meeting to the ultimate death of the victim. You have an hour on the evening. So then,
Yeah.
do you want me to go to the hour?
Go to that hour.
The grand jury testimony of the defendant, it's at transcript 6, pages 29 to 30. The defendant talks about that they got out of Boomers at 12:50 or 12:45 a.m.
Meaning both the victim and the defendant?
He and the victim and the defendant left together from Boomers. So that's where the time comes from, the grand jury testimony. In his statement to the police on December 2nd, which is, he arrives at the police station 22 minutes or so after the murder, and then stays there for a couple of hours and talks to the police officers. In that statement, he said when they came out of Boomers, they planned to meet later to smoke some dro, he called it, that's D-R-O. And the meaning of dro is hydroponically grown marijuana. It's very high quality, and in fact, the victim's friends, Paul Mullen's friends, talked about how they had been together earlier in the evening playing video games, and he had actually received a quantity of high-quality marijuana. Later on, after the murder, that high-quality, large quantity was found by the victim's sister, but another quantity, open bag of marijuana, was found on Paul Mullen's table in his apartment as well. So this smoke some dro, this was something that the victim did indeed have as well. So they're coming out of Boomers. The defendant's first statement says, we came out, we're going to meet later that night to smoke some dro. We go our separate ways. And that, we know the time period of that is 12:45 or 12:50, and that's from the defendant's, that time comes from the grand jury testimony. So that's where you have the deliberate premeditation and intent. So then you have to show his participation in the commission of the murder. And what you have here is the defendant luring the victim to the location where he will be murdered almost immediately upon the victim's arrival. The call is at 1:44. He gets there. The victim calls the defendant. Where are you? I'm at Hess. And the victim gets there almost immediately. So the defendant, he didn't make the call.
Excuse me. The victim calls to ask the defendant where he is?
Yes.
How do we know that?
It's from the defendant's statement to the police. Also, there's a picture of the phone.
Defendant states that he asked me where to meet him?
Yes. And he's already at Hess. The defendant is at Hess. The victim calls him, where are you at? I'm at Hess. In addition to that, you have the phone, picture of the victim's phone, Paul Mullen's phone, and it has the time, 1:44, and it has the defendant's phone number. So that's where you get the time period for that. So it's almost an hour after they have arranged to meet later to smoke some dro. So the defendant knows he's coming, and then, of course, later, in the defendant's later statements to the police, he says, whoa, I never said that. I never said we were going to meet. I had no plans to meet him. So he goes back and forth. I admit that. The evidence shows that he goes back and forth on whether they were planning a meeting. But you take the evidence in the light most favorable to the Commonwealth. And his initial statement on December 2 says that they plan to meet. So then you have the defendant has parked his car in front of Hess, and he buys the blunt, and then he moves his car. And I'm not clear on whether he moved his car before or after the phone call. I think it was before the victim's phone call. And he moves his car to a location where the security cameras will not record. So he is bringing the victim to the place where the shooting occurs. And he is placing his car in a place where any shooter will not be recorded. Now, the defendant raises the question, well, how would he know that the victim, in his brief, how would the defendant know that the victim would sit in that car? And the defendant described his actions. He opened his car door on the driver's side, he had the car running, the music playing, and he put the blunt on the console, and when the victim arrived, he said, you roll, and this, his grand jury testimony says, you roll them like a professional, you do it much better than me, you go roll the blunt, and I'm gonna go buy some pizza. He also suggested in his prior statements, he sat down, I opened the door for him, he sat down in the driver's seat to roll the blunt, I went in to buy the pizza. As he's going in to buy the pizza, he tells the victim where he's going, and the victim says, get me a pizza and a soda, get me a slice and a soda too. And the defendant goes inside the Hess, he's on the video camera for 3 minutes, he does not buy any pizza at all. In fact, he stands around talking to people. He talks to the clerk, not about anything important, he doesn't know the clerk. He's just saying hello, what's up, that kind of thing. And then after 3 minutes, he goes and stands outside. 2 minutes later, the shooting occurs, and he's in front of the Hess. So that shows, that evidence shows that he facilitated this commission of this murder by putting the victim in the place where he would be shot 10 minutes after his arrival, putting him in that seat, making sure the security video would not record, and then giving himself his own alibi by walking inside Hess where the video cameras do record. Now, then the big question here is, was it done knowingly? And I would suggest the evidence of knowingly goes heavily on his consciousness of guilt. But most important, there's two important points that I want to get at. And one is Kiki Turner, Takesha Kiki Turner. She saw the shooting. She's the eyewitness to the crime. The defendant knows her. He doesn't know her name as Takesha Turner. He knows her as Kiki. He knows who she is. She comes in and she says, they're shooting outside. She says to her friend Epps, Serena Epps, we gotta go. It's Serena Epps was driving. She's the woman.
Say to him, they're shooting your car?
The defendant says, Kiki told me they're shooting at your car, somebody with masks. That's the defendant's statement. And in his initial statement to the police, he says, I don't know anybody in Hess. That denies knowing Eldon, he denies knowing Kiki, he denies knowing Epps, he denies knowing the mother of his own child, who was in Hess earlier that evening. Said, I didn't know anybody in Hess. And some girl came in yelling, telling me they're shooting at your car, but I don't know her name. And later on, he says, the woman who came in and talked to me and told me they were shooting at my car, that was Kiki. And in his initial statement, he said she made a statement about masks. At grand jury, he confirmed the person who told him about the masks is Kiki. Kiki said she didn't talk to the defendant at all. She said she didn't mention masks at all. She went in to get Epps, because Epps is her driver. And the defendant comes in shortly after Kiki, and then he walks out with Eldon. Eldon and Serena Epps are boyfriend and girlfriend. She's carrying Eldon's child. That's why she's the designated driver that night. So they're walking out of Hess. The two women are walking out, heading to their car. Now, Eldon is at Hess because the defendant has brought him. The defendant offered Eldon a ride home from Boomers that night, which is the Safari Club. But he said, I got to stop at Hess first to get the blunt, which reinforces his statement he's planning to meet to smoke the dro later with the victim. I got to get to Hess to buy a blunt. And then when he gets to Hess, Eldon's like, he's not going to take me home. So he goes in and starts talking to his girlfriend who happens to be there. So the defendant says to Eldon, you guys got to get out of here, or you got to get out of here, and the two men escort the two women to the car. At that point in time, the defendant knows that Kiki has seen the shooting because she's the woman who's come in. He knows that the police are going to get called, there's a shooting out there, and he knows that he is telling the people to leave.
All right. What you say? Kiki and Eldon both testified at trial.
Yes, and Epps.
And Epps. So what do they say?
They say initially...
Did the defendant tell him to get moving, get out of there?
Eldon, I think, confirms that. But the defendant testified that he told them to leave. I'm not testified. The defendant told police that he told them to leave.
All right, but he first told the
You know,
police he
now-
didn't know
I'm sorry, no,
anybody.
I'm sorry. I think it's Alden's testimony that he says that tells them to leave. And then the two men walk the two women out. The defendant says he doesn't know any of the people in
I thought you
his
said
initial
the
statement.
defendant had left the inside.
He was standing out in the front of the store. You can see his legs. It's pointed out in Detective Clark's testimony.
Then he went back in?
And he followed Kiki in. And there was some dispute over what the video showed, whether he came in before Kiki or came in immediately after Kiki. And so you can see that in the cross-examination of Detective Clark. But then he hides the eyewitness's identity from the police. And so that, he hinders that police investigation in that way. Kiki.
Okay.
And he hides that identification until February. And February 6th, he tells them, oh, no, it was Kiki. Kiki's the one who said that. And so what you see from that testimony is, one, he knew that masks were used, even though Kiki said she never mentioned masks and didn't talk to the defendant. And so that's one inference that the prosecutor is drawing. And the other inference is that he knew those people who were in that Hess station, and he told the police he didn't, and he's the one who was telling them to leave. Now, Kiki wanted to leave anyway, but
Did Kiki say that the assailants wore masks?
yes.
That was her testimony. She
That's
just
her testimony.
didn't recall saying
She-
that to the defendant.
Kiki saw one man,
One man.
masked, do the shooting. Jane Moraes is another woman in the parking lot who saw two men with masks walking up but didn't see the shooting. As soon as she saw the men with masks, she thought, we should get out of here.
Can you turn to the grand jury?
Sure. And as I'm turning to the grand jury, I would just note also the Commonwealth supports the claim made by the prosecutor that there's a very strong inference that the man in the driveway was indeed the shooter that the defendant was meeting with and then denied later, and that would be the evidence of the knowingly along with his consciousness of guilt. As to the grand jury, there's a major problem with the defendant's claim is that the trial judge heard this evidence. There was a motion in limine, and he had an evidentiary hearing. Lieutenant Warmington testified. And the trial judge found the defendant was not a target of the investigation at the time of his grand jury testimony.
And how was the trial judge defining target?
Well, you can see his findings at page 25 of the defendant's record appendix. And in those findings, it's 25 and 26, he said, he came in response to the summons. At the time, he was not considered a target of the investigation, but the police believed that he knew more than he was saying and that he was not telling them everything. He was treated like all other witnesses while at the grand jury. He waited in the hallway for his turn. And rather than quote all of it, so he's essentially saying he was treated like every other witness.
So you say that's nice that the federal court feels that you need to notify people who are suspect and not just targets. We don't have to do that?
It's the U.S. Attorney's Office policy,
Yes.
as opposed to the federal court.
Okay.
And it says subject or target.
Subject. You can
And
tell I've never been a
subject-
federal prosecutor.
Subject
So it
is
says
defined as
subjects.
a person whose conduct is within the scope of the grand jury investigation. And, obviously, you can look at this as persuasive authority, but you do have to look at the law that governs this case. If you were to make a new law, then it should be prospective and not apply to this particular case. In this case, we have a judge's finding that this person was not a target and therefore not entitled to any warnings. And further, and I don't believe that I'm not positive, I don't believe the defendant was suggesting he was a subject. He was saying he was entitled to target warnings. I believe that was the nature of the discussion, but I'm not 100% positive on that. But what we look at is the trial judge's findings and say, were these findings supported by that evidence? And if they are, then this court should adopt those findings. And that's Commonwealth versus Walker that's cited in my brief. And in this case, indeed, his findings were supported by that. The defendant was not in custody. He left after his testimony. He was not arrested for 6 months. The indictment against him did not come down for 6 months. That grand jury investigation proceeded from February all the way to October.
And is there any evidence in the record as to what happened during those 6 months that caused the Commonwealth to move from thinking him to be a suspect into one that they indicted?
I believe, I know the prosecutor made a proffer that there were numerous witnesses that were called to the grand jury after, I forget the exact number, and that those witnesses were the persons who discussed the defendant's statements of, "I intend to kill." I don't think that Lieutenant Warmington specifically talked about what proceeded after in the grand jury testimony, because
Guessing the prosecutor didn't know at the time that he called the defendant what those witnesses were going to say in the grand jury?
that was 2 months after the murder. So in December 5th, the murder occurs, grand jury testimony had begun, and on February 10th, the defendant testified. The indictment wasn't returned until October, and numerous witnesses were called in that time period, and I believe those statements of the intent to kill is when that came out. The difficulty with that is that Lieutenant Warmington was obvious, he's the witness at the motion to eliminate, and he was not, obviously, was not present during the grand jury presentation.
Now,
I don't think he testified about that and the nature of that evidence.
Is there a certain illogic in law which says that when we fear that a person may feel compelled to speak because they are in custody, we say in Miranda, or the U.S. Supreme Court says in Miranda, that you must advise them of their rights. But where somebody truly is compelled to testify because they receive a subpoena, there is no requirement that there be an advice of rights.
Well, if you look at the difference between the two, and it's this court's decision in Damore, and this court's decision in Damore is that
But in Damore, there were rights given.
Miranda rights were given. And in this case, the defendant was given his Miranda rights 4 days before.
No, but in Damore, I think Damore was advised of her rights before the grand jury. She wasn't told she was a target.
That's exactly right. Damore was not told she was a target, wasn't given a target warning, but she was given her Miranda rights. Miranda rights are only required when someone is in custody. The defendant was not in custody during any of this time, but he was given his Miranda rights 4 days before when he spoke to the police. And Damore says a person has a right to choose whether to testify or to invoke their rights. They do not have the right to commit perjury. So I would suggest in this case, if you make any change in the rule, it should only be prospective. I don't think that you should do that in this case because this case doesn't present a good example of why you should be doing this. You have the defendant's other statements render that grand jury testimony almost entirely cumulative.
No, but you have, maybe, I don't know that, and I mean, you may well be right, but just listening to you today, there's been a number of times when you were going through the sufficiency of the evidence, when you were referring specifically to the grand jury testimony
Right.
as being necessary pieces of where you were getting the sufficient evidence.
Right, so I can point out the key points. One is that 12:50 time, the time of the closing of Boomers. One is Sean Montero's criminal history. The defendant was able to give an exculpatory statement explaining his fear of being blamed because of his race, that the victim was Caucasian and he was African American. There's references to his calls to James Welch, who that was earlier in the evening. There's obvious grand jury investigatory where, you talk to this person, they list off all the people that he had talked to that night. The issue of the mask with Kiki, he told that statement about the mask, that the woman said the mask, in his very first statement. Then the second statement, he identified her as Kiki, and then at grand jury, he puts the whole thing together. It's Kiki said the mask. So I would suggest, and those are the key points that have any kind of difference, and they're cumulative of other evidence in this case. So in this case, certainly reversal is not required because it is cumulative evidence. And certainly it is, there is no basis for a change in the law in this case where the defendant was not a target and Damore covers the area.
Thank you.
I apologize for going
That's
over.
okay, Counsel. Thank you.
Thank you.